Thank you, Mr. Dressel and Mr. Rahul, for finishing this on time. It's always interesting to come to the stage after lunch. I hope everybody had great lunch and you're enjoying your afternoon nap. By the time you wake up, I'll be through with my presentation.
No chance.
I think I also congratulate the organizers for organizing this excellent session with a bunch of generics and the topmost or one of the top branded companies being there, and some lawyers on the table. So it's a very interesting mix, and that's what we're starting on. So one of the very interesting things that we've been wrestling with is compulsory license challenges. I'll be speaking or addressing things that are going on in the compulsory license. I myself, as Mr. Dressel pointed out, I'm an attorney in India. We litigate, prosecute companies across the globe and global companies in India. I represent Talwar Advocates and TT Consultants. We've got offices Taiwan, Japan, US, and India, of course. So the timeline has been for compulsory license has been very active. This slide lists out the various things that have happened in the domain ever since last few years. It's kind of every year is getting more and more curiouser. 2014 promises to be no less. It started with 2005, India opened up to the product patent regime. There were immediately thereafter there were some compulsory licensing applications. NATCO asked for a compulsory license for Tar Seva. Going forward, there was cell entry, which was again asked for. That went nowhere. Thereafter, the first compulsory license was granted in 2012. The controller's decision came through in 2012. There were more and more voluntary licensing applications or voluntary license demands which were coming through, and there were government circulars related to compulsory license or questions related to compulsory license for 3 more products. And then the first compulsory license which was granted against Nexavar was upheld in 2013. And there was another compulsory license application which was filed and rejected in 2013. So this year promises to have a lot of play in this area. And one of the things that I always say to my colleagues, to my friends across the border, across the world, is that it now is kind of out of the government domain. It's out of the policy domain on a larger scale. We are in the domain of judiciary. Most of the decisions which the Act also provides within are not government decisions. They are usually to be taken at a quasi-judicial interpretation of law level. We are as a country, as a society, we are a very innovative society. So, people talk about non-practicing entities across the world. People talk about patent trolls across the world. Some people also compare, the way some, branded companies or companies with products are being asked for compulsory licenses or voluntary licenses as being the Indian version of NPE. We might have their own views about it, both for or against. But there is a law. There is a provision in a law, and that provision is being, it's being tested, and that's where we stand. So it has to be tackled, at that level. And I would re-emphasize that this is actually a legal issue, right? This is no longer only in a policy domain. So when there are talks about what is the Indian government doing, etc., 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 it is more now in the realm of courts, because now, as you would know, the Bayer case is now, or the compulsory license case is now not with any quasi-judicial body as well. It is before the judicial bodies. It's before the High Court, and then we go on to the Supreme Court. Another very important aspect is the public perception. When the compulsory license was actually granted, and if anybody was privy to the coverage after the 3D case or after this compulsory license case, most of what was what was covered in the media or covered was, at least in India, or was fed to the Indian public at large, was this is a step in the direction of cheaper medicines. That's a perception which was just, there was no contrary perception which was put across. So that's a perception that was, that has to be again tackled, and so it brings you to a very interesting place where the law might say whatever it is, but the perception that is being put across, the news that is going across, is that compulsory license is for cheaper medicine. There is no second point of view which is being put across, which is something that has to be tackled. However, the law itself has a lot of inbuilt checks and balances, and those checks and balances are what I will like to portray and put forward. And these are my views, and I like to put them forward and take you through. The law itself, first of all, I think is one of the most interesting piece of drafting that I have come across in my career. It's drafted more as a guideline or a provision. It is not drafted as pure law. It is drafted as a provision. So two sections that are that mainly deal with 83 and 84. I'll just read through them, and show you how they're more drafted as guidelines. It says that patents are granted to encourage inventions and secure that the inventions are worked in India on a commercial scale. That they are not granted merely to enable patentees to enjoy a monopoly for importation of the patented article. And then it says patents granted do not impede public protection of public health and nutrition, and should act as instrument to promote public interest, especially in sectors of vital importance to socio-economic and technological development of India. So this is actually a part of our statute. Then it goes on to state actually the working condition, the conditions under which the compulsory license can be granted or can be considered to be granted. So after 3 years of grant, if the patentee is not fulfilling reasonable requirements of the public with respect to the patented invention having not been satisfied, patented invention is not available to the public at reasonably affordable price, or patented invention is not worked in the territory of India. So these are three major points on which any application that goes through in a court of law has to be taken up. Now each of them has ample points related to reasonable, what is reasonable, as anybody would, anybody who's a student of law would or a litigator or has addressed courts would know that all these words that are put in there leave ample scope for courts and patentees and applicants and both sides to actually provide for enough space where they can actually put in reasonable issues, so that they can actually once, or if you're expecting a compulsory license application or a voluntary license application, you can actually have enough checks and balances put in your policies. At the same breath, in the same section, there's an 84(6) which says, which actually favors the patentee, and goes on and says, in consideration of the application filed under this section, the controller shall take into account the nature of invention, the time which has elapsed since the sealing of the patent, and the measures already taken by the patentee or licensee to make full use of the invention. The ability of the applicant. Now this is the applicant which is coming up and filing for a compulsory license. So the ability of the applicant to work the invention to the public advantage, and then the capacity of the applicant to undertake risk in providing capital and working the invention if the application was granted. as to whether the applicant has made efforts to obtain a license from the patentee on reasonable terms and conditions, and such efforts have not been successful within a reasonable period as the controller may deem fit. Now, India is a big country, a huge population, especially in when it relates to medicines, right? Now, I would urge all practitioners or anybody who's in a position where you're advising advising companies for their practices in India when they're holding some considerable set of patents in India, to look at this and make sure that whenever there's an application that comes through, you can throw these across to the challenger for say, and make sure that you raise all these questions in a response that you get, that you have to file against a voluntary license application. Moving on, I continue by saying that compulsory license, as an overview of the provision, it has to be issued or it has to be filed before you actually. Before there is an actual application that comes in, a challenger has to come in with a voluntary license application. There are provisions in the law which also provide for national emergency provisions, which is as per the section 92. There are provisions in the law which also provide for export in terms of when there is an insufficient or no manufacturing capacity in the manufacturing sector. So there are some Doha provisions which have also been provided in the section. Now, what are the positive things that applicants or the patentees should do? One is the statement of working requirement, the Form 27. We would recommend that you file your Form 27s rigorously and diligently. You should, at least flood the patent office with as much information as possible. There is a playing for stumps provision. Make sure that as long as you've applied for some manufacturing licenses in India and they are pending, there is a provision in the law which provides for some adjournment of proceedings where these applications or manufacturing licenses have been filed. Take steps to take as many steps as possible. Apply for clearances. Then the section 84E, which provides for if working of the patented invention in any part of India on a commercial scale is being prevented or hindered by importation of from abroad. Now, this section relates to if you're importing the product into India, does that constitute working? Now that provision is still open, whether importation satisfies the provision of working. So that the Intellectual Property Appellate Board has held that part is still open. So even if your manufacturing facilities are under active approval and you're still importing some goods into India, that could still be okay in certain cases. So that part of the law is still not fully tested. Then, of course, if you're not in a pricing control regime, make sure your pricing mechanisms are justified, and you actually go back and justify your pricing mechanisms, and make sure that the pricing is reasonable, as is the case in the law also provided. Now, again, if you're targeted, there are certain things that you can actually take steps. One is, again, when you actually the relevant date is when you actually when the application is actually filed before the controller. So on that date, whatever your position is, that's usually frozen, but that does not stop you from continually taking steps to actually reach out to the public at large. And and one of the very important aspects is when you actually get a voluntary license application. When the challenger actually sends you a notice saying, "Hey, I want a voluntary license," make sure that you have, you put the points on the card. You actually negotiate with the challenger. The part of negotiation is an extremely important position. that is when you can actually question the challenger, so as to say. That is actually when you can put questions to the challenger. That is actually when you can take as much information as possible from the challenger. Now, there was a recent case where against Bristol Myers Squibb, there was a voluntary license application. The challenger actually did not wait for did not bother to give answers, and on this ground itself, a prima facie case was not made out, and the compulsory license application was thrown out. So it's important to at least make sure that you negotiate at that stage and make sure that you get as much information out, or try and get as much information out at that stage itself. The other is take on the applicant. As I said, the law also is not being tested fully. We just have one compulsory license granted, and that too is pending in the High Court. The other one is, so there have not been ample judicial adjudications as to speak. And again, some of our points that we provided is, compare the pricing with foreign countries, though. Participate in as many voluntary programs as possible. Make sure you negotiate at the voluntary license stage. Courts in India also provide for statements at bar. Make sure that you use those provisions effectively. There are challenges for interim applications as well possible. Make sure that interim stage applications are also taken to different courts. So you can always challenge interim applications or interim decisions at the court. And then, of course, even after a compulsory license has been granted, there is provision in Section 94 for termination of compulsory license on any of the conditions not having been met. So again, very important to make sure that you play for stumps, which is a very cricket terminology. Make sure your application is pending before the government authorities. Make sure there are enough tie-ups or joint ventures in progress. I'm just left with the last slide. And and you can adjourn applications and make sure that you spend times. The most classic example for playing for stumps is this application which was dismissed on maintainability. Now, this slide actually provides for the timeline. As you can see, there are enough provisions where you can actually, both at the prima facie stage and the later stage, make sure that you that there are some times that you can play for. At least make sure that the evil days is postponed as much as possible. So with that, I'll like to thank you, and we'll take questions at the end of it. Thank you.
Thank you very much.